Good evening to one and all present here. We at HSNC University welcome you to the inauguration of the DM Harish School of Law. We are privileged to have with us today our chief guest, Honorable Justice Rohinton Nariman, former Judge of Supreme Court of India and former Solicitor General. We welcome our guests of honor, Dr. Kishu Mansukhani, President of the HSNC Board, Dr. Niranjan Hiranandani, Honorable Provost of HSNC University, Mr. Anil Harish, Trustee and immediate past President of the HSNC Board, and Trustees of HSNC Board, Mrs. Maya Shahani and Mr. Lal Chelara. We also extend a warm welcome to the principals and vice principals, faculty and students of HSNC University colleges who are all with us today to witness the inauguration of the DM Harish School of Law. We begin, and we now have with us Secretary of the HSNC Board and former Vice Chancellor of HSNC University, Mr. Dinesh Panjwani, who is an eminent educationist and administrator with a vast experience in institutional building of over 43 years. I request you, sir, to deliver the welcome address.
Thank you for inviting me. Good evening. I feel privileged to give opening remark on this auspicious day. Thank you, Mr. Anil Harish, Trustee HSNCB, and prime motivator towards the establishment of DM Harish School of Law as Law School of the HSNC University, for assigning me this responsibility. Even though it is referred as welcome address, I consider it as opening remark on the establishment of the HSNC University and the Law School. Establishment of the HSNC University is culmination of hard work of the founders, successors, and most importantly, the current leadership of the HSNC board and the principals and staff of the HR, KC, and BTT college over the past 70 years. It did not happen overnight. A robust process started in 2018 with Mr. Anil Harish at helm of HSNCB, culminated in taking shape in 2019 with Mr. Kishu Mansukhani at helm of HSNCB, and in 2020 with Dr. Niranjan Hiranandani as provost. The university steered itself into the real world of academic excellence. The trustees, Mr. Lal Chelara and Mrs. Maya Shahani, contributed immensely with their support and inputs from time to time. This team, supported by members of the executive committee and board of governors, are pillar of strength, intellectual and financial of the HSNC University. The HSNC University, which started its operations with established faculties of arts, science, and commerce, is working towards strengthening academics of these faculties and incorporating academics of other faculties to make this university a center of academic excellence, catering to varied needs of the young generation and quest of knowledge for school, college dropouts, and professionals. In keeping with this thrust, the university leadership, well supported by the HSNCB leadership and the guidance of Provost, worked for establishment of law, management, and technology faculties in its formative year itself. Establishment of DM Harish School of Law is a milestone for the HSNC University, that in its very first year, it subjected itself for the rigid inspection norms of the Bar Council of India and created state-of-art infrastructure and technology advanced academic facilities. Well supported by the qualified faculty, fulfilling the norms of the Bar Council and becoming one of the few universities having law school commencing all law programs, 5 years, 3 years, LLM, and research in its formative year itself. The curriculum and academic infrastructure is developed under able guidance of Dr. Kavita Lal Chandani, Dean Faculty of Law of the University, who along with the well-wishers of the board, Dr. Nambiar licensed also with the Bar Council in fulfillment of all statutory requirements. Dr. C.V. Achra, Director Law School under the guidance of the current Vice Chancellor Dr. Hemlata Bagla, is working hard for admissions and initiation of academic instructions for the first academic year of the school. A doctor and lawyer are an integral part of survival of a welfare democratic society. Hence, it is very important that an institution imparting law education should align itself with values and a robust character. Mr. D.M. Harish is not a name, but epitome of values and character of the legal profession. More importantly, these values have now been percolated into the third generation, and involvement of the D.M. Harish family with the school and legacy of HSNCB, well preserved and strengthened by the current leadership, shall always ensure right values and character for the law school. A very interesting similarity in hard work and values of our chief guest and the trustees of the HSNCB, that they are second generation of the migrants who were uprooted from hearth and home, hence understand the importance of hard work, values, and character. Our chief guest is described by Chief Justice of India as a lion who guarded judicial institution. Honorable Sir, we feel honored with your presence, and I conclude with a quote from the book of your father, eminent jurist Padam Vibhushan Fali Nariman. I quote, "When you name a lawyer who has done well, people ask you from which chamber. The chamber is important. It establishes the hierarchy and cultural tradition in which the lawyer has been reared." Unquote. We assure you, sir, that for the years to come, this law school shall establish the highest order of hierarchy and cultural tradition for the law students. Namaskar.
Thank you, sir, for your opening remarks. They gave us a deep insight into the foundation of the beginning of this D.M. Harish School of Law. We will now screen a film that will take you through some glimpses of the university.
We welcome you on the educational planet of the HSNC University. Here, university footprints branch out into various constituent colleges. Those are HR College, KC College, and BTTC, and the university schools including Niranjan Hiranandani School of Real Estate, D.M. Harish School of Law, and many others. The university campus is situated at just a few minutes distance from the Bandra Worli Sea in the heart of the city, making it easily accessible to people traveling from all across Mumbai. D.M. Harish School of Law, the HSNC University welcomes you at its extensive and pristine campus. These floors are designed, dedicated, and positioned, keeping all the prerequisites of the law education for the students in mind. Next is the indispensable assembly hall and the auditorium. Moving up to the second floor, we have Seminar 1 and Classroom, adjacent to which is the spacious conference room with ICT facilities to conduct interpersonal interactions and vital meetings. We also have another mini conference room on the same story. On the third floor, we have a very important part of the campus, the Moot Court Hall, the epicenter of the entire campus, which is designed to hone the soft skills of the law students, like the techniques of presentation of the cases, legal analytical research, and debate skills. We then move to the learning hall. adjacent to which is the Facilitation Center, also known as the Administrative Office. This space is dedicated to being the Director's Office and Assistant Director's Chamber and the conference room. We have two more spacious learning halls. On the 4th floor, the space is beautifully maneuvered and entirely dedicated to learning halls, which are air-conditioned and have a scenic sea view, with proper learning and teaching facilities. Finally, we come to the 5th floor of the building, which opens up to two large learning halls and other significant spaces. Like the computer center, with 65 computers that are armed with the highest configuration. Alongside, we have the common rooms for men and women, which are separated into two different rooms. Ending with the Ratna Harish Knowledge Center and Library, a complete one-stop resource center. For more information, visit our website at www.hsncu.edu.in.
And with that video, I'm sure you are all able to see the state-of-the-art infrastructure at the DM Harish School of Law. We now have with us Trustee and President of the HSNC Board, Dr. Kishu Mansukhani, who is one of the strong pillars of our board, overseeing several prestigious educational institutions known to be actively involved in a host of social and humanitarian activities, and also holds several charitable trusts. I request you, sir, to deliver your presidential address.
Very good evening to all of you. Honorable Chief Guest, Justice Rohinton Nariman ji, Dr. Rohinton, Provost HSNC University and Trustees of HSNC Board, my colleague trustees, Anil Harish, Mr. Lal Chelaram, Maya Shahani, Professor Anjwani, HNCB Board Secretary and former Vice Chancellor of HNCB University, Present Vice Chancellor, Dr. Hemlata Bagla, Principals of various colleges, staff, distinguished guests, and educationists. Hearty welcome to you all to this inaugural ceremony of Dream Project A.M. Harish School of Law, which is a part of HNC University, Mumbai. It is a great honor to have with us today a former judge of Supreme Court of India, Justice Rohinton Nariman ji, as our chief guest. Sir, we at HNCB family welcome you at this August gathering of legal luminaries. We look forward to hear from your words of wisdom and guidance and blessings. E.M. Harish School of Law is one of the schools of HSNC University, which is supported by the Hyderabad Siddharth College Board. The board has earned national and international recognition in the field of education. Our board manages 24 colleges and schools, educating 45,000 students every year. E.M. Harish School of Law has been introduced with a very noble objective to provide socially relevant, comprehensive legal education. School is named after a great, humble soul and legal luminary, late Advocate D.M. Harish. D.M. Harish was born in our native land, Sindh. During his scholarly achievements, acquiring the first position at the high school examination in the entire province of Sindh at that time, he was introduced in Sindh Scholar League, a very prestigious league at that time. After completing legal education from Mumbai University, he founded an internationally known firm, D.M. Harish and Company, specializing in taxation, property, and corporate law. He built a tremendous goodwill among the industrialists and the professionals. He established D.M. Harish Foundation, which endeavors to support the cause of education by providing grants to the needy students. The education was dear to him. He had said he was conscious of the fact that his personal life and personal success was mainly due to his education and dedicated hard work. He has authored 8 volumes on income tax law. His contribution to field of law remains. We are confident that the D.M. Harish School of Law will contribute immensely to the field of education and ethical values. Thank you once again for being today with us. Your presence has made this gathering more memorable. We wish all of you happy, healthy, and safe and progressive New Year. God bless you all. Jai Hind and Jai Jhulelal.
Thank you, sir, for your inspiring words and taking us through the life and work of Mr. D.M. Harish. We are now pleased to have with us Dr. Niranjan Hiranandani, the Honorable Provost of HSNC University and Trustee of the HSNC Board. In addition to being a renowned entrepreneur whose real estate business, the Hiranandani Group, is considered as the producer of the best quality housing and commercial premises in the country, he is also the visionary behind the Niranjan Hiranandani School of Real Estate. I request you, sir, to deliver the Provost Address.
A very good evening to each and every one of you. It's such a delight, such an honor, such a pleasure to be here today. And in the midst of one of the most famous luminary lawyers and judicial leaders of our country, a man of great integrity, a great honor, Sir Mr. Rohinton Nariman, we are very, very, very honored that you have come over here for the purposes of inauguration of the School of D.M. Harish. Mr. D.M. Harish has been a legal luminary, but most of all, I remember him with great fondness. When I, as a young chartered accountant, used to go to him for advice. And many times I would go to him and take ideas and thoughts from him. And many times went with him to him with complicated ideas in order to see that I could save taxes. And he said, young man, you are just starting life. Keep it simple, keep it straight, keep it in with people will look at you with honesty and integrity. That is what he told me when I was a very, very young person. And that holds me in good stead even today. If I today enjoy any minutiae of that integrity in my profession as a builder or a chartered accountant, it is I owe to Mr. D.M. Harish and what he taught me at that time. Hence, his name, which has been outstanding in the field of legal profession, has actually delighted all of us to name this school of law after him. Sir, you enjoy a great reputation in the field of legal profession. You became a senior lawyer at the age of 37. I still don't know anyone in this country who became a senior lawyer at the age of 37. That itself shows the kind of reputation that you enjoyed with the legal profession at such a young age. Sir, we look forward to your words of wisdom, your blessings and your kindness and your guidance today in order to take this inauguration of this school, which will lay the foundations of hundreds and thousands of young people to go into this profession. So we are delighted to look forward to this. I'm grateful to the president of the board, Mr. Kishuban Sukani, my other trustees, especially Mr. Anil Harish, who has taken so much effort in order to see that this school is put up. To the others, Mr. Dinesh Panjwani, thank you. Kavita Lal Chandani, Dr. Achara, Himlata Bagla, and all the rest of the teams who have really taken tremendous amount of efforts to put up these educational institutions and take it forward. We have really waited for this occasion to happen. We have already got 3 schools of law. The 3 schools of law hold great amount of reputation. However, we found that we needed one more to take it to the next level. And we are delighted here today to put up the 4th school under the HSNC board. As you must have seen, the infrastructure, the development that we have put into this infrastructure is starkly different and at a different level completely than what we have done for any other institution of our board on earlier days. This itself is an indication of what changes are taking place in the HSNC board and also the new university that has been given to us by the government of Maharashtra. And we are blessed with this opportunity to create new lines of education in fitness with the national education policy. Sir, we look forward to your blessings and also the direction in which our school should take. Also, what are the new ideas and opportunities that our students should learn and how the future of such an institution should be brought about. Thank you once again for coming here today to bless us and take this institution forward. Thank you very much, each and every one of you who has joined over here to participate in this inauguration. Thank you very, very much.
Thank you, sir, for those motivating words. We now have with us Mr. Anil Harish, trustee and immediate past president of the HSNC board. He has been ranked by the prestigious Legal Directory of Chambers and Partners as a leading tax lawyer. And in addition to being a highly noted lawyer and partner of the law firm DM Harish & Co., it is he who has spearheaded the creation of this DM Harish School of Law. I request you, sir, to please address the gathering.
Honorable Mr. Justice Rohinton Nariman, trustees, principals, teachers, students, and all associated with the HSNC board and HSNC University, honorable judges, lawyers, and distinguished ladies and gentlemen. My father, Mr. D.M. Harish, was a true votary of education and believed very strongly in the transformative power that education has on a person's life. In 1997, he talked about this in a speech which he gave and wished for the day when the quality of education in India would be so high that more students would come from overseas to India than would go from India for studies. He was a scholar himself, and in the last few months of his life, he completed writing his books on income tax. After his passing, as a contribution to the cause of education, D.M. Harish and Company and D.M. Harish Foundation, along with Government Law College, in the year 2000, started the National Moot Court Competition. And this, in 2005, became the first international moot court competition held in India and continues since then. This was possible only on account of the unstinted and enthusiastic participation of the honorable judges of the Bombay High Court and of the many lawyers who spent countless hours judging the rounds. As Albert Camus said, real generosity towards the future lies in giving all to the present. And that is what the honorable judges and lawyers and teachers have been doing, giving to the present and being generous to the future. I would also like to say here that education and knowledge have no boundaries, and the D.M. Harish Moot Court competition will continue with Government Law College, which is the alma mater of so many of us, but we will do something new here in this school. Ladies and gentlemen, the Hyderabad Sindh National Collegiate Board is a great institution. It started in 1949, soon after the partition of India, and now runs a large number of educational institutions and has about 45,000 students and has educated lakhs of students over these decades. In 2019, the HSNC board was one of the very few educational institutions from all over India to be given the right to form a cluster university. And this was done with 3 of the wonderful colleges of the board, which are household names in Mumbai: HR College, KC College, and Bombay Teachers Training College. Now, HSNC University has started 2 new colleges, DM Harish School of Law and Niranjan Hiranandani School of Real Estate, and plans many more. China is known as the world's factory, but India should certainly become one of the great universities of the world, and the HSNC board and HSNC University and all the dedicated teachers and students are surely contributing to that. So much has gone into the setting up of DM Harish School of Law. The trustees of HSNC board have been amazing, always so forward-looking and supportive. Dr. Kishu Mansukhani, President, Dr. Niranjan Hiranandani, Provost of HSNC University, Mrs. Maya Shahani, and Mr. Lal Chalaram, and the board members and founders and past trustees have truly been visionaries. And I am so grateful to the HSNC board for setting up the School of Law in the name of my father and the library in the name of my mother, Mrs. Ratna Harish, who herself went from Sindh to Firozpur in Punjab in 1944 to do her MA in philosophy before her marriage, and then studied law in Bombay and became a lawyer when my sister Shobha and I were little. Principal Dinesh Panjwani, who was Vice Chancellor of HSNC University, has led the great effort to set up the university and also the School of Law, and left no stone unturned. He and Dr. Kavita Lalchandani have also worked tirelessly to get the approval of the Bar Council of India. I also appreciate the work of Dr. Himlata Bagla, Vice Chancellor of HSNC University, a person of limitless energy, and of Dr. Achra, who has 3 PhDs, and of Dr. Balani and many others. The thoughts, ideas, and effort of all the members of our family, my wife Hani and our son Adhiraj and daughter Rishika, and of Shobha and Harish Jaktiani and of Sharan Jaktiani, and so many more at all times have been incredible. Everyone at DM Harish and Company and our clients and friends over the years, judges, members of the tribunal, officers and lawyers and chartered accountants, have been so important in my father's life and in ours, and been the foundation of the school. Although it is now almost a quarter of a century since my father shuffled off this mortal coil, almost every day members of the firm and clients and others talk to me about him. I am very fortunate in that there is a law college named after my father, DM Harish School of Law, and one named after my father-in-law, Nari Gursani Law College. There are very few persons in the world, I'm sure, who are in this position. But I do know one other person who is similarly placed, my wife, Hani. Ladies and gentlemen, renowned jurist and author A.V. Dicey had propounded that the rule of law provides for 3 pillars: supremacy of law, equality before the law, and predominance of the legal spirit. It is respect for the law and the recognition that the legal spirit must be paramount, which are the motivating factors for anyone to dedicate their lives to the profession of law. And this will be the mission of the new School of Law, to inculcate this respect for the law and these feelings in the students who will in course of time be qualified adequates, and some of whom will aspire to be judges. The life of a judge is a life of immense sacrifice in terms of self-imposed isolation, meticulous and disciplined hard work, and dedicated scholarship, and above all, the onerous task of passing judgments which are balanced and devoid of bias, and not just for the present, but for posterity. Honorable Justice Rohinton Nariman is an exemplary personification of these ideals, and the subject of his talk is fundamental and critical for our system of government, and indeed our lives. Because, as John Locke said as far back as 1689, wherever law ends, tyranny begins. It is therefore apposite that Honorable Mr. Justice Nariman thought of this subject for his inaugural address, and this will surely augur well for the decades to follow and the generations of students who will trace their inspiration to this day and the ideas and thoughts enunciated. Ladies and gentlemen, we are today in the presence of an extraordinary judge on an extraordinary occasion, the setting up of a new educational institution. So I will end with the words of Oscar Wilde. The ordinary gives the world its existence. The extraordinary gives it its value. Thank you very much, Honorable Mr. Justice Nariman, and thank you all.
Thank you, sir, for your inspiring words and ushering us into this enthusiastic beginning with the creation of this new School of Law. We now have with us Dr. Kavita Lalchandani, who is the Dean, Faculty of Law, HSNC University, and Principal of the KC Law College, who has a vast experience of more than 28 years in the subject of law. I request you, ma'am, to introduce our eminent keynote speaker for today.
Thank you. Honorable Mr. Justice Rohinton Nariman, Trustees of HSNC Board, Vice Chancellor of HSNC University, Registrar of HSNC University, Principals from Board and other law colleges, lawyers, invitees, and the dear students. A very good evening to one and all. Friends, it's my absolute honor and proud privilege to introduce our distinguished guest, Honorable Shri Justice Rohinton Nariman, former Judge, Supreme Court of India and former Solicitor General of India. Honorable Mr. Justice Nariman pursued his legal studies at the Faculty of Law and secured second rank in the University of Delhi. He pursued his further studies, Masters in Law from Harvard Law School, and he is son of a well-known distinguished jurist, Sri Pali S. Nariman. Justice Nariman started his career by enrolling himself in the bar in the year of 1979 after obtaining LLM degree and brief distinct practice in maritime law in New York for a period of 1 year before returning. Justice Nariman's stature was enlightened by his excessive attention to the minute details and his remarkable grasp of the complicated facts and the underlying legal issues. All these qualities elevated him to the designation of Senior Advocate of Supreme Court at the just age of 37 years. As a lawyer, Sir also served as the Solicitor General of India and was appointed in the year of 2011. He has 35 years of experience with the bar, during which time he argued numerous landmark cases, including important constitutional matters, and has over 500 reported Supreme Court judgments to his credit. Considering the judicial aptitude and the fierce independence of the legal doyen, in 2014, he became the fourth person to be directly elevated from the bar to be the judge of the Supreme Court of India. His elevation has been a matter of pride for the youngsters practicing in the court. Honorable Shri Justice Nariman is a brilliant, learned, and thoughtful judge. He is considered an expert in the comparative constitutional law and civil law. He set up the Supreme Court Welfare Trust for the welfare of the lawyers and to encourage the young talent. He was a member of Supreme Court Mediation Committee. He also served as a member of Bar Council of India. A man with deep interest in history, philosophy, literature, and science, Honorable Shri Justice Nariman authored several notable judgments, and as a member of many constitution benches, his contribution to some landmark verdicts will remain carved in the history of country's evolving jurisprudence. Mentioning few like the judgment of Shreya Singhal versus Union of India, which struck down the Section 66 of Information Technology Act, Puttaswamy case related to the right of privacy of an individual, Navtesh Singh Johar case relating to decriminalizing section 377 of Indian Penal Code. And like this, many more cases are there. The big list is too big, which I can't mention over here. Honorable Chief Justice of India said on the day of the retirement of Honorable Shri Justice Nariman that it is like losing one of the lions that guarded the judicial institution. The person known for his erudition, clarity, and scholarly work. So we are really so very happy, and we feel very proud that on this auspicious occasion, we have a great personality to inaugurate the DM Harish School of Law. So dear friends, we are extremely happy to have a great personality, Honorable Shri Justice Rohinton Nariman, on the inauguration of DM Harish School of Law as the chief guest and keynote speaker for today's program. With this, I extend a very hearty welcome to Honorable Shri Justice Rohinton Nariman and request him to deliver the keynote address and also inaugurate our DM Harish School of Law. Thank you.
Good evening to you all, dignitaries, ladies and gentlemen. The rule of law has not come down as manna from heaven. As a matter of fact, it has involved centuries of struggle, first between an absolute monarch and elected members of parliament, and in its second phase, between the elected members of parliament and the other so-called branches of government. But to begin at the beginning, we must go back in Anglo-Saxon jurisprudence to the year 1066. 1066 happens to be the year in which two cataclysmic events took place. One was Halley's Comet passed over England and most of the world, which it does every 76 years, heralding perhaps a new era. And the second was the victory of William of Normandy over King Harold in England, thereby ushering in a new dynasty of Norman rulers. Originally, they had Anglo-Saxon rulers, now Norman rulers came in. And with Norman rulers came a more brutal and ineffective series of laws together with a monarch who was more or less absolutist in the manner in which he executed them. William the Conqueror came and died, and his son, William Rufus, William II, happened to be much more ruthless than him. Fortunately for England, he also died in a hunting accident in 1100. That led to the youngest son, that is Henry I, taking over. Now, Henry I's Coronation Charter is perhaps the first important document that we have in English constitutional law which established the rule of law. The Coronation Charter was a charter by which the nobles bargained with Henry I and made him lay down the fact that excessive taxes would not be collected, that justice would be tempered with mercy generally, and that, most importantly, in the 14 clauses of that charter, clause number 13, which said that we will go back to the laws and the manner of their execution of the saintly Edward the Confessor, who was there prior to Norman rule. So Henry I's Coronation Charter, therefore, laid down what in modern terms could be called very fundamental rudiments of the rule of law. What followed from this charter was various other monarchs who came in until we come to perhaps one of the most despised monarchs in English history, the Plantagenet King, John. Now, John had a running battle with his nobles, as a result of which he was ultimately forced at Runnymede, which is a place midway between London and Windsor, to actually sign what was called the Magna Carta. Now, why it is called the Magna Carta is to distinguish it from a forest charter of the same time. The forest charter granted all persons, unlike the Magna Carta, which granted only free men, which was 10 or 20% of the population of the time. The forest charter granted rights in the royal forests to the common man, rights such as the collection of wood, the collection of forest produce, etc. The Magna Carta was signed, however, between the barons or the lords and King John. And what the barons were able to wrest from him was contained in 63 clauses. We are concerned today with the famous clauses 39 and 40, which lay down the rudiments of the rule of law as we know it today. Clause 39 stated specifically that no free man shall be arrested or detained otherwise than in the courts of law and by trial by his peers or by the law of the land. And clause 40 said, to no free man shall we sell, delay or deny justice. Clause 61, which was since dropped, was an interesting clause because that was a clause which showed you the distrust the barons had of this terrible monarch. Clause 61 said that if for some reason King John were not in fact to enforce the charter, then 25 barons would be at liberty to go against the king's property, but not against the king's person. Magna Carta was signed in June 1215. Very shortly after, and interestingly, it was a document in Latin, not in Norman French. The idea perhaps being that the Pope should ultimately sanction it. Far from sanctioning it, Pope Innocent III was one of the extremely strong medieval popes, annulled it in August of that year. King John died of dysentery soon after in 1216, and his young son Henry III at age 9 had to take over the realm. Fortunately for the rule of law, Henry III decided in favor of Magna Carta so that in 1225 you had printed copies of it circulating around. This went on into the reign of his son, Edward I, and in 1297, you actually had Magna Carta put, and that is clause 39 and 40 put, into a statute of parliament, where it still remains. So today, we have the ancient 39 and 40 now embodied as clause 29 of the 1279 or 1297 statute, which continues to obtain in England. Moving a little forward from this, we come to Edward I's grandson. Edward III was another extremely powerful monarch. Not only did he also reprint Magna Carta, but he made some small changes as well. And one of the interesting changes that he made was that in clause 39, instead of trial by your peers, what was substituted was due process of law. A very interesting phrase that has crept into the US Constitution, but did not ultimately find its way in our Constitution. So from 1354 onwards, we find that Magna Carta of 1215 embodied the rule of law contained in England against absolutist monarchs, giving Parliament certain rights so that Parliament could speak on behalf of the persons who elected the members of Parliament. We now come to another absolutist monarch, Charles I, who was the second Stuart king. You will remember that England was ruled by many dynasties. None of whom were English. So you first had the Norman French, and after the Battle of Bosworth Field in 1485, you had the Tudors. And after the Tudors, you had the Stuarts. The Tudors were Welsh, the Stuarts were Scot. And of course, finally, the House of Hanover, which continues today, which is German. And all this took place for the reason that you had to have Protestant monarchs ruling England after the disastrous reign of Queen Mary I, who tried to bring back Roman Catholicism. So you would much rather dig up somewhere for some Protestant king, though he didn't know English, George I, for example, and bring him to the throne, than put a Stuart monarch on the throne if he happened to be Catholic. But coming back to Magna Carta and coming back to the rule of law, we find that the next important English document is 1628, the Petition of Right. Now, this Petition of Right was against Charles I, who was another absolutist monarch. And the idea was that forced loans could not be taken from the people by the king, and arbitrary imprisonment made if forced loans were not given. Parliament therefore asserted its right in no uncertain terms, quoting from Magna Carta yet again. Charles I, of course, paid for his sins with his head, and he was executed on a sinister day, 30th January, 1649. Now, 30th January conjures up two other very sinister events. One is the accession of Hitler as Chancellor of Germany in 1933 on the same day. And one is the assassination of our beloved father of the nation on 30th January in 1948. Moving on to Charles II now, who was the son of Charles I. We find that he was the monarch who married Catherine of Braganza and has a direct connection with Mumbai, where this school is set up. Because in 1662, Catherine of Braganza brought with her, apart from various other things, the islands of Bombay as dowry, which was then handed over to Charles I, who in turn handed it over for 10 pounds to the East India Company. But during Charles II's reign, in 1679, we had a very important measure passed by Parliament, which was the Habeas Corpus Act. And this ensured that the writ of habeas corpus would in fact be given by the King's Bench all over the realm in order to enforce the rights of Magna Carta. Interestingly, this act ought never to have been passed. It got through the Lords 57 to 55 only because Lord Grey, first as a joke, but then thereafter seeing that the joke would have ramifications, counted one extremely fat lord as 10 lords, and therefore got to the figure of 57. Otherwise, it was in fact not passed by 55 to whatever else it was. I was never very strong in mathematics. So, by an accident of history, we have this famous Habeas Corpus Act of 1679, yet another important document in the evolution of the rule of law in English constitutional law. And finally, of course, with the expulsion of James II, who was the Catholic monarch who suddenly gave birth to a male heir and who was expelled in the glorious revolution of 1688. Glorious, why? Because not a shot was fired. James slunk off to France, and William, that is his son-in-law, took over as William III together with his Protestant daughter, Mary II. Now, 1689 marks another watershed because this Bill of Rights, so to speak, was passed by Parliament, where various constitutional guarantees as we know them today in our Fundamental Rights chapter were granted, including things such as no excessive fines or bails and no cruel and unusual punishment. From this, we move 100 years forward to the first great constitutional document known perhaps to mankind, that is the US Constitution of 1789. Now, this constitution makes landmark strides in the rule of law for this reason, that for the first time, you have a practical application of the Montesquieuan doctrine of separation of powers. You have power now diffused between various branches of government, so that in the place of one absolutist monarch or an equally absolutist parliament, if you may put it that way. You have power now distributed among Congress, who is to make laws, among the executive, who is to execute these laws, and among the judiciary, in which cases between states and states or states and individuals are to be fought out, and ultimately their decrees to be enforced by the executive. The original US Constitution didn't contain a Bill of Rights. That came only by amendment. And the first 11 amendments incorporated important freedoms, which we take almost for granted today. The very first amendment incorporated the right to free speech and press. The Fourth Amendment was equally important in that searches and seizures, which were illegal and without warrant, were interdicted. The Fifth, extremely important amendment, dealt specifically with life, liberty, and property not being taken away except by due process of law, which phrase, as I have told you a little earlier, was found in the statute of Edward III in 1354. And the Eighth Amendment equally bodily lifted from the 1689 Bill of Rights the interdict against cruel and unusual punishments. Now, all this ultimately led to our own constitution, which was promulgated in 1950 after shaking off the colonial era to which we were subject. The preamble to our constitution is like a mini constitution because it gives you the values and principles of our constitution and the rule of law, therefore, that is contained therein. The preamble begins with the words that we, the people of India, are now going to give to ourselves a constitution in which India is a sovereign democratic republic. Each word is pregnant with meaning. India is now sovereign in the sense that it governs itself. It is no longer a colony of another superpower situate abroad. It is democratic in the sense that you have universal adult suffrage by which governments are then elected in order to govern the people. And this is done by means of free and fair elections, which is then handed over by Part 15, so to speak, of the Constitution to an independent election commission of India. The safeguard given is that the chief election commissioner, who may be flanked by other election commissioners as well, has a fixed tenure and cannot be removed save and except by impeachment, which is a difficult, almost impossible proceeding. So sovereign and democratic show us that we now govern ourselves through the ballot, and that the ballot must be free and fair in terms of the elections held. The fact that we are a republic again shows us that we are not a monarchy. Indeed, we have shaken off autocratic monarchical rule, but we are now a republic, meaning that we are republican in the American sense of the Montesquieuan doctrine of the separation of powers and the diffusion of powers so as not to waste too much power in any one constitutional authority. Interestingly, the two words added by the 42nd Amendment, namely socialist and secular, were proposed by Professor K.T. Shah in the Constituent Assembly. Dr. Ambedkar said, no, it wasn't necessary to have either socialist or secular because socialism was a creed which you could find in any case in the directive principles of state policy. And secular, of course, our constitution was. So he found it unnecessary at the time. However, now that we have these two words, they are both pregnant with meaning. Socialist, in its broad sense, denotes a government for the people, by the people. So in the broad sense, you are governing for the people as a whole, who you will, of course, treat with equal respect. you also have, apart from this, the concept now of secularism. Now, you are a secular state in two senses. One, the state itself has no religion. And second, the state does not in any manner look upon one religion with favor and another with disfavor. In short, all religions are to be treated alike. This is a very, very important concept in today's milieu. And a little more will be said about it a little later. Then, of course, you have the great justice clause, that there must be justice, social, economic, and political. Political justice was delivered almost at one stroke by having universal adult suffrage. Economic justice is how the teeming millions who are so poor in this country are to be pulled up by their bootstraps. And of course, social justice is the justice of those who traditionally have been downtrodden, such as our Harijans, all of which are contained in various provisions and articles in our constitution. Most importantly, after justice, we have the concept of liberty. Now, liberty is extremely important because not only is liberty of thought and expression, but it is also liberty of belief, faith, and worship, adding strength to the word secular, so that what distinguishes this democracy from other so-called democracies is the fact that you have freedom of speech and expression, and that everybody is entitled to profess whichever faith in religious terms he chooses. Apart from this, you also then have equality of status and opportunity. Equality of status being the age-old concept, the Magna Carta concept of everybody being equal before the law. As a matter of fact, Bracton very early in the 1200s had said, as a matter of legal commentary, that the king himself is under both God and the law, because the law itself made him king. So it is in this sense that everybody is equal before the law, which is fleshed out in our Fundamental Rights chapter. And finally, you have the cardinal and extremely important principle of fraternity. Now, fraternity denotes something positive. There's a positive ring to it. That is, all men are brothers, all persons, whatever caste, creed, etc., are brothers and sisters. And this will ensure, this alone will ensure the unity and integrity of the nation. So having done with the preamble, we find that the rule of law embodied in it is very clear. The rule of law is much more than just clauses 39 and 40 of Magna Carta. The rule of law, or the rule of the constitution in this country, would therefore require power to be diffused among the great branches of government, and the individual citizen given certain freedoms which inhere in him. And for this, we go straight away to the Fundamental Rights chapter, or chapter 3 of the Constitution of India. It begins with the definition of state in Article 12. But Article 13 is the key to this chapter, because Article 13 fleshes out in no uncertain terms the doctrine of judicial review. Now, judicial review in the United States has to be established by case law. There was no Article 13. As a matter of fact, in the seminal decision of Marbury versus Madison, you find that William Marbury was a justice of the peace who has been given a commission by the Adams administration, which commission had not physically been delivered to him, so that he could not therefore take oath and sit as a justice of the peace. He therefore petitioned the Supreme Court directly and said, look, there is the Judiciary Act of 1789, the 13th section of which specifically states that you, the Supreme Court, can give me the writ of mandamus that I am asking for. Namely, I am asking for a writ commanding the authorities to hand over my commission. Now, Chief Justice Marshall was the person who, as Secretary of State of the Adams administration, had actually signed that commission. So it was improper for him to have taken up the case in the first instance. But it is obvious that he took it up for the purpose of establishing what, according to him, very early in his Chief Justiceship, he was Chief Justice for 34 long years, the doctrine of judicial review. So he did this by doing one other amazing thing. He could also have construed the 13th section of the Judiciary Act as it stood, stating that the writ of mandamus would apply only in the appellate and not original jurisdiction of the Supreme Court, because it followed upon a clause conferring appellate jurisdiction. He did no such thing. He was very anxious to lay this down as a doctrine. So what did he do? He pitted Section 13 against Article 3 of the Constitution, which is the supreme law under Article 6, said that the two don't square, because Article 3 clearly made it known that the only original jurisdiction of the Supreme Court would be in cases involving states, ambassadors, and the like. In short, not between states and individuals, like William Marbury. And therefore, what he did was to strike down the 13th section, saying it is unconstitutional because it violates Article 3 of the Constitution of India. Now, all this laid down what is known in our constitutional law as judicial review. Having all this before them, the founding fathers thought it important to lay down in an article of the Constitution explicitly that all laws that are made by legislatures and or by the executive must conform to the fundamental rights chapter of the Constitution. Otherwise, they are to be declared void. So with this voidness comes a very, very important concept of the rule of law, that it is the judiciary who sits as the ultimate arbiter even of laws made by the legislature. And if those laws do not conform to the Constitution, then they will be struck down as being invalid. Now, often we are told, and we have been reminded quite often, even in the recent past, that look, you judges are not elected representatives. You are appointed. How then can you take it into your ken, so to speak, to annul laws made by a legislature which consists of elected representatives? Fortunately for us, the answer to that question is in the Constitution itself, and we don't need to labor it. But these heads keep rearing themselves from time to time and have to be scotched by the courts clearly stating that, look, in our constitutional law, it is the higher judiciary consisting of the Supreme Court and the High Courts who ultimately are the arbiters who decide, and who decide that laws, if they are unconstitutional, must go. As a matter of fact, we have gone much further than just this. And we have laid down in the seminal decision of Kesavananda Bharati of 13 honorable judges, the fact that the Constitution itself, if it is amended, contrary to what we call its basic structure or the principles contained in the provisions as fleshed out from the preamble, the constitutional amendment itself would be liable to be struck down. Now, the justification for all this comes really from a very interesting paper number 78 of the Federalist Papers. The Federalist Papers, incidentally, were written by three great Americans. One, Justice John Jay, who happened to be their first Chief Justice. He wrote 5 of them. 2, by the father of their Constitution, James Madison, who was the 4th President of the United States. And the bulk of them by Alexander Hamilton, who was the first Secretary of the Treasury in the Washington administration. Now, Hamilton's paper number 78 deals specifically with the judiciary. And 78 tells us that whereas the legislature has the purse and the executive the sword, the judiciary, by its very nature, is the weakest branch of government and the least likely to upset the political rights of the people, for the reason that it hath neither force nor will, but only judgment. And even for judgment, ultimately it has to depend upon the executive arm to ultimately enforce those judgments. So the rationale given by Alexander Hamilton for the US Constitution holds good today as well. Unelected judges are the best arbiters between the citizen and the state, and one state against another state, for the reason that ultimately they go by judgment, not by force or by will, and are therefore the least harmful of the three so-called institutions of government. Coming back to the fundamental rights chapter, we now find that Article 14 tells us that all persons are equal before the law, something that Magna Carta told us long, long back, and also adds that the laws will equally protect you. You have the equal protection of the laws as well. Now, what is the meaning of the equal protection of the laws? This comes out well in an early American case, Yick Wo versus Hopkins. It's a judgment of Justice Matthews speaking for a unanimous US Supreme Court in 1886. And the case involved Chinese laundrymen. Now, Chinese laundrymen were aliens in the sense that they were not US citizens. So the first question that arose was whether they had any rights at all and whether the 14th Amendment would apply to them. The answer given was, you don't have to be a citizen so long as you are a person. And they are persons, therefore, the 14th Amendment or the equality clause that would apply to them. Second, the law laid down that so far as San Francisco was concerned, all laundrymen had to take out licenses. And those licenses could only be given to structures in which those laundries were contained, provided they were made of brick. If they were made of wood, then no license could be granted. The Chinese laundryman came forward with a case stating that every single Chinese laundryman happened to have his laundry in wooden structures. And there were some 300 odd, as opposed to 80 odd by other competing Americans. The court ultimately said that the equal protection of the laws means really the protection of equal laws. And if the law is administered in an unequal fashion, then the law itself would be struck down. This was a very important doctrine so far as the rule of law was concerned. So the protection of equal laws therefore means that when you actually make the law neutral on its face, but de facto really hitting out at one group, then you will look at the de facto and not the de jure position and say that the protection of equal laws has been denied. We now move on to the other great articles of the Fundamental Rights chapter. You have Article 17, which abolishes untouchability. I told you that that was a promise that was made in the very beginning, and that is how you achieve social justice, which is set out in our great preamble. So 17 is not only outlaws untouchability, but makes it an offense, which is punishable by law. 18 equally states that nobody can receive titles. And it's important here in the context of all persons, therefore, being equal before the law. We now come to the 7 freedoms contained in 19. And 19 is a very, very important article. 19 contains the difference between democracies like ours and dictatorships that are veiled as democracies. 19(1)(a) contains the single most important and cherished human right, which is the right to freedom of speech and expression. Now, unfortunately, of late, we have had in this country young persons, students, stand-up comedians, and the like, all being booked for freely criticizing the government of the day under sedition laws, which are really colonial in nature and have no place under our constitution. On the other hand, you have persons giving hate speech, what is called fighting words in Chaplinsky versus New Hampshire, or hate speech, actually calling for the genocide of an entire people. And we find the great reluctance somehow of the authorities to book these people. It was heartening to note, at least, that a little later, the vice president of the country in a speech said that hate speech is unconstitutional. Not only is it unconstitutional, it happens to be a criminal act. It is criminalized in 153 capital A and 505C of the Indian Penal Code. Unfortunately, in practice, though a person can be given up to 3 years imprisonment, this never really happens because there are no minimum sentences prescribed. If we really want to strengthen the rule of law as contained in our constitution, I would suggest strongly that Parliament amend these provisions to provide minimum sentences so that they act as deterrents for others who make hate speech of this kind. We also have, unfortunately, the other higher echelons of the ruling party not only being silent qua hate speech, but almost endorsing it. We heard the other day from the very head of the party a juxtaposition of a Mughal emperor known for being a bigot, namely Aurangzeb, as against Shivaji was known to be a secular leader. Now, if, as a matter of fact, fraternity is a cardinal value in our constitution and you want to engage persons in becoming a brotherhood, I would have thought that you should have chosen Mughal emperors such as Babur or his grandson Akbar. Akbar was famous for being perhaps one of the most secular rulers that any nation has ever known at any point of time. And he took after his grandfather Babur. Interestingly, at this point, I want you to read, or I'll read out to you a letter written by Babur to his son Humayun 1 year before he died on 11 January 1529, telling his son as to how to rule Hindustan, which he had conquered, so to speak, after the Battle of Panipat. He says, "O my son, the realm of Hindustan is full of diverse creeds. Praise be to God, the righteous, the glorious, the highest, that he had granted thee and unto thee the empire. It is but proper that you, with heart cleansed of all religious bigotry, should dispense justice according to the tenets of each community, and in particular, refrain from the sacrifice of the cow, for that way lies the conquest of the hearts of the people of Hindustan, and the subjects of the realm will, through royal favor, be devoted to thee. The temples and abodes of worship of every community under imperial sway you should not damage. Dispense justice so that the sovereign may be happy with the subjects, and likewise the subjects with their sovereign. The progress of Islam is better by the sword of kindness, not by the sword of oppression. Ignore the disputations of Shias and Sunnis, for therein is the weakness of Islam, and bring together the subjects with different beliefs in the manner of the four elements, so that the body politic may be immune from various ailments. And remember the deeds of Hazrat Taimur Sahib, so that you may become mature in matters of government." And he ends by saying, "And on us is but the duty to advise." A beautiful letter. His grandson carried all this into practice. His grandson, in fact, had the famous Ibadat Kharma built in 1575, where persons from all the religions of the world, including the Charvak school, which is the ancient Hindu materialist school, were present and who debated freely before the emperor. The emperor, in fact, greatly not only acknowledged but furthered the cause of every religious faith. So much so that many religious faiths said that they had exclusively somehow or the other got to the emperor and converted him. The emperor finally, of course, came out with his Dine Ilahi, which failed because it was too eclectic. It had no priesthood, etc. But the idea was fantastic. The idea was try and bring together mankind as a common whole, which custom has divided. So when you have 19(1)A being administered as it is being administered today, there is a big red signal that is put up so far as the rule of law is concerned. It is time to do away completely with these sedition laws and allow free speech, so long as ultimately it does not exhort somebody to violence and end up as being hate speech. Apart from 19, you also have the great freedoms in 20 and 21, which harken back to Magna Carta. That is, that no person shall in any manner find his life or liberty curtailed or denied, except by due procedure established by law. In Article 22, you have the two great safeguards of having a lawyer of your choice the moment you are arrested and being produced before a magistrate within 24 hours of your arrest. Now, these various freedoms, including the great freedoms that you now find in Article 25, where every person has the right to freely profess every religious faith that he or she chooses, and the cultural rights of the citizens of India, which are all contained in Article 29, which perhaps is an article which exists only in our constitution. I have not found it in any other. It says every section of the people have the right, and it's an absolute right. It is not subjected to any reasonable restrictions. So this absolute right is now given to persons to preserve their culture in its widest sense. Most important of all is Article 32, which again is a unique feature of our constitution alone. Article 32 makes it clear that it is a fundamental right of every citizen of this country to move the Supreme Court so that their fundamental rights be enforced. It's a remarkable article. You can either do this or go to the High Courts under Article 226. And the judiciary, therefore, is set up as being the person or the institution which ultimately gives a person the right to his fundamental rights. The judiciary itself is set up as an independent body under Article 124, where the government of the day has to consult the Chief Justice, which in practice means the judges appointing themselves to it, so that government interference is removed. And it's with this independent judiciary ultimately, therefore, that the rule of law is ultimately maintained. Another very important article is Article 144. 144 says all authorities, civil and judicial, shall act in aid of the Supreme Court. Now, this is something that is explicitly laid down given the history both of the United States and of India. So far as our history is concerned, we actually had a judge called John Peter Grant, an English judge, who in 1829, because Governor Malcolm refused thrice to execute a writ, actually locked his court up and set sail for England. He did so because of the ultimate weakness of the judiciary, as was pointed out in Hamilton's paper 78, because ultimately you have to rely upon the executive to actually enforce your orders. Now, not only did he set sail, but he came back, but this time as a chastened person, because the authorities somehow sided with Governor Malcolm and sent him back with two other judges, so that, in their words, a wild elephant would sit between two tame ones. The wild elephant ultimately landed up in Calcutta to great public acclaim and was loved by the Indian people. Equally, at around the same time, Chief Justice Marshall went out of his way to decide a particular case in favor of a cleric called Worcester, called Chisholm versus, not Chisholm, but Worcester versus Georgia. And the state of Georgia apparently had entered into a treaty with the Cherokee Indians, which it did not somehow or the other honor. Worcester was required to take out a license under Georgia's laws and went to the Georgia Supreme Court. Supreme Court said, yes, you must take out that license. The US Supreme Court reversed, Chief Justice Marshall saying that as and when you happen to be on Cherokee land, it is Cherokee Indian law that applies and not Georgia law. Andrew Jackson, who was the president at the time, cocked a snoop at the Supreme Court and said, Marshall has laid down his judgment, let him enforce it. Today, such things are almost unthinkable. Why do I say almost? Because we've also had the Sabrimana case, which all of you must be familiar with. Despite 5 learned judges of the Supreme Court having laid down that women between the ages of 10 and 15 can enter, no woman was allowed to enter. And most unfortunately, the Supreme Court itself sent this judgment by way of a review petition, something unheard of, to a bench of 9 judges to be decided along with other matters. And thereby, Sabrimana has now gone into limbo. So we find that whatever we take for granted in terms of constitutional rule of law cannot ever be taken for granted. It is very important to remember that eternal vigilance is necessary not only for liberty, but for liberty enforced by courts, which is the rule of law of this country. I end on this note, and I thank you all very much. I wish the DM Harish School of Law all the very best in the future. Thank you.